At this morning's presentation, I'm joined by a panel comprising Jonathan Pawlowski. He's a partner at Collyer Bristow and head of our construction unit. He's an adjudicator and a member of the RICS Construction Adjudicators Panel and a fellow of the Chartered Institute of Arbitrators. He's the current chair of the Council of the Society of Construction Law and has served on the council since 2012. He's also a member of the Technology and Construction Solicitors Association, the Adjudication Society, and the Solicitors Association of Higher Court Advocates. I'm also joined by Aimee Stevens. Aimee's an associate at Collyer Bristow in our commercial real estate team. She specialises in residential development and acts for a number of property developers. Aimee's got particular experience with residential home builders. She's advised on a number of residential and commercial transactions and has particular expertise in Help to Buy. Finally, I'm joined by our guest speaker, Daniel Dovar. Daniel's a barrister from Tanfield Chambers. He specialises in real estate and leasehold law, and with a particular emphasis on landlord and tenant. He's been described by the Legal 500 as superb, particularly good at the upper tribunal, and an incredible advocate. He is recommended as a leader in the field of real estate litigation in Chambers and Partners, who have described him as having excellent knowledge of property-related disputes. He's the co-author of a book called Business Premises and of Residential Possession Proceedings. He's editor of the Landlord and Tenant Review, as well as a contributor to Chambers Service Charges and Management. Daniel has recently been appointed by the Lord Chief Justice as a Deputy Chancery Master. So in terms of the format for this morning's webinar, I'm going to discuss some methods for making overage agreements stick. Aimee will then look at issues around ground rents and leasehold terms following the investigations by the Competitions and Markets Authority. Daniel will then provide an overview on how to read the registered title with some pointers for spotting pitfalls before you purchase. And finally, Jonathan will discuss issues arising from delays and disruptions to the construction program. Each of our talks will take approximately 10 to 15 minutes, and there will be a short Q&A session at the end. Please put your questions in the Q&A portal at the bottom of the screen. So before we start, we're going to have a quick poll question, the results of which we may use in the follow-up to this webinar or even in a future webinar. So on your screen, you will see a number of options. Out of these options, which do you consider the main challenge or constraint currently facing your business in delivering high quality residential property? So it's the main challenge or constraint. And I'll leave it for half a minute so that you can read through the options and put in your reply. Right. Right. So the we have got some results here coming in. So it seems the main challenge, definitely by a long way, 70%, is planning delays and complications. And then on equal second place, 10%, is delays in sourcing materials and shortage of available land. That's great. Thank you very much for doing that. So I'll just turn to my talk on overage. So what is overage? Overage is a contractual mechanism to permit a seller of land to benefit from a subsequent increase in the value after having sold it. I'll start off with a couple of cautionary tales. Firstly, in a 2017 case of Sparks and Biden, overage was to be triggered on the sale of the last of several newly built houses. The developer tried to avoid triggering overage by occupying the property itself and leasing the rest on a short-term basis. Now, although the court said this frustrated the overage provisions and the developer had an implied obligation to take positive action to sell the houses, this is a warning as to the sort of issues that can arise. So second, in the 2021 case of Fathers Field Developments Limited and Namula's Pension Trustees Limited, so that's just 2021, this year, a buyer bought a golf course subject to a restrictive covenant prohibiting for 30 years residential development without the consent of the original covenantee. The buyer applied to the Upper Tribunal Lands Chamber to discharge or modify the covenant under Section 84(1) of the Law of Property Act 1925. He was trying to, it was in relation to a cottage built in 2006 and also a couple of new houses which were being constructed on the land. There are a number of points that arise from this case, but a couple of salient ones to note are, firstly, it highlights that a restrictive covenant can be discharged or modified by an application to the Upper Tribunal under Section 84. Secondly, in this case, the transferor did not retain any land. A restrictive covenant will not automatically bind a buyer of the servient land unless it touches and concerns the land retained by the covenantee. So this was a problem for enforcement. The transferor got around this particular problem by getting a covenant preventing dispositions without the new buyer providing a direct covenant in the original covenantee's favour. The Upper Tribunal has no jurisdiction to discharge or modify a traditional positive overage covenant where the share of future development value is specified at the beginning. But please note that a positive covenant needs to be backed up by a land registry restriction on the title of the servient land to make it stick. Overage provisions are particularly difficult to get right, and they frequently result in disputes. So I'm going to turn to, so what are the benefits of overage? From a seller's point of view, overage can help maximize its potential financial return from the sale of land by receiving both an initial price and a share of any future increase in value. For a buyer, the main benefit is that it can avoid overpaying for the land at the outset. An overage payment is often it's contingent on any future increase in the value. So the buyer can take advantage of paying a lower initial sum rather than an inflated value based on the land's anticipated development potential, which may never be fully realized. There are a number of questions which need to be addressed in relation to overage. For example, how long the overage should apply, what are the trigger events, and how the overage is calculated. Of all of these, however, the most important and the focus of this talk is how to secure the buyer's obligation to pay the seller any overage which has been agreed. Ensuring overage is enforceable is not straightforward. A positive obligation to pay overage will not automatically be enforceable against a successor entitlement. A negative or restrictive covenant can be enforced against successors, but only if it is genuinely negative in nature and the seller keeps back some land capable of benefiting from it. So what are some potential methods of securing overage? Well, here's 4 of them, potentially. Firstly, you can secure it by a charge over the title. Secondly, you can try a restriction on the title. And thirdly, perhaps a direct deed of covenant from successors as a requirement in the actual documents, the agreement for overage. And fourthly, potentially obtaining a guarantee from someone of sufficient covenant strength. There are, however, other less common methods of securing overage. For example, a reverse option or grant of a long leasehold with positive or restrictive covenants which get released on payment of the overage, or possibly a retention of a ransom strip and ransom rights, or possibly even a freehold rent charge. But these are not as common, and I won't dwell on them, save to say each of them is fraught with its own difficulties. So a charge is the best form of security, but it may not be acceptable to a developer, or in particular, its funder. A restriction is much more likely to be acceptable, provided it does not hinder the developer from actually redeveloping the land. So the most common method, in my experience, of securing overage is a restriction against the title. Land buyers and their funders often accept such a restriction. However, if the title restriction is wrongly worded, it can roll over into subsequent titles of the flats or house buyers. This makes it hard for house builders. They find it difficult to achieve plot sales unless the restriction is reworded to prevent such a rollover. There are ways to prevent the restriction rolling over into subsequent titles. It needs to exclude certain dispositions, such as plot sales and sales to housing associations, management companies, electricity substations. From a developer's point of view, it also helps if it is worded so its solicitor can self-certify that excluded dispositions will take effect free of the restriction. So to recap, sellers should consider how they can protect or secure the buyer's obligation to pay overage. Whilst the agreement itself will create a personal contractual obligation on the buyer to pay the seller overage, in and of itself, this is generally inadequate. This is because the buyer might be of insufficient covenant strength, may even cease to exist at the point that overage is to be paid, or for other reasons. So a seller will almost always seek to secure their right to any future overage payments against the land itself. The terms of any such protection or security will be a matter for negotiation, but they could include registering a restriction on the buyer's title to the land, prohibiting the buyer from further on selling the land unless their future purchaser also agrees to be bound by the overage, or unless the overage due on that transaction is paid, or registering a legal charge over the land, such that when the buyer wishes to subsequently dispose of the land, the buyer would be required either to redeem the charge by paying to the seller any overage due, or ensure that the subsequent purchaser of the land also enters into a charge to continue to protect the overage. Of the methods described above, the one most frequently used is a restriction on the buyer's title. Your solicitor will need to be consulted to make the necessary land registry and company house applications to ensure that any overage obligations are correctly secured against the company and the land in question. The aim is to provide adequate security for the seller of the land whilst not tying the buyer up in knots so that it is unable to actually develop and sell units at the development once they have been constructed. So thanks. I'm now going to turn to Aimee, who will discuss the issues around ground rents and the Competitions and Market Authority investigations. Aimee.
Thank you, Alex, and morning, everyone. During my section of today's webinar, I intend to focus on the situation relating to ground rents following the investigation into leasehold practices by the Competition and Markets Authority and the announcement of the Leasehold Reform Ground Rent Bill earlier this year, and to look at what trends and practices have started to emerge. To start off with, I'll quickly recap on what we mean by ground rents. A ground rent is a fee charged by a landlord or a freeholder of a property, payable by the tenant. The terms of the payment of the ground rent will be set out in the lease between the two parties. Older leases or leases from a local authority often have nominal ground rents, which are either a peppercorn or are somewhere around the £10 mark, however, per year. However, in modern leases, it's much more common to see a ground rent payable of anywhere from a few £100 to over £1,000 per year. The level of the ground rent being demanded will predominantly depend on the landlord, the area in which the property is situated, and the age of the lease. Modern leases are also likely to include provisions for the level of ground rent to be reviewed. There's no one-size-fits-all to this, and the type and frequency of the rent review varies considerably from property to property, as it will again depend on the landlord, the area in which the property is located, and the age of the lease. By way of example, rent reviews can be fixed increases, doubling, or they can be index linked. And they can be reviewed as often as every 5 years, up to every 25, or even every 100 years, depending on the term of the lease. So why is there all this fuss about ground rent at the moment? It's estimated that around 4.5 million households in England are held on a leasehold basis, and that makes up 19% of all housing. I'd expect that most of these leases will have a ground rent being payable under the lease. They should therefore be a relatively well-known concept. They also seem fairly harmless on the face of it. And for those keen on legal history, the charging of ground rents can be traced all the way back from Roman law through to the modern day. So as I say, why is there all this publicity at the moment, and why do landlords and developers need to take notice? Unfortunately, it's come to light that flats and houses are being sold in England and Wales with clauses contained in the lease that mean that ground rents will rocket over the life of the lease. The most troublesome and notorious of these ground rents is the doubling ground rent. In leases with doubling ground rent provisions, the ground rent will double at set intervals. For the sake of example, let's say that a lease has a ground rent of £250 per year, which doubles every 10 years. At face value, that doesn't sound too dangerous, and that's something that's really quite a common provision in leases. However, as you can see from the table that I've put on the slide, whilst the sum is manageable for years 1 to 10 at £250, and perhaps even at years 11 to 20 at £500, by the end of year 30, the ground rent is £1,000. If you jump forward to year 81, it's £64,000 per year, and then it becomes over £1 million a year by year 121. So a ground rent that doubles every 10 years over the term of a 125-year lease certainly does become problematic the later into the term you get. This has meant that many households have been left with properties that are unmortgageable, can't be sold to new purchasers, and therefore are effectively worthless. So what's been done? As a result of these unfair leasehold practices becoming more prevalent, the government has now stepped in, or at least they have to some extent. Earlier this year, the Leasehold Reform Ground Rent Bill was published. The aim of this legislation is to make home ownership fairer, more transparent, more secure, and ultimately more affordable. Once this legislation is in place, it will mean that ground rents on a new long residential lease cannot be more than a peppercorn per year. And so it will effectively restrict the ground rent to having no financial value. This is a good thing for purchasers at face value, and the bill's currently in the House of Commons for first reading. So I would note that whilst there is some progress here, it's still some way from being passed into law. Separately, the Competition and Markets Authority has also launched an investigation in mid-2019. A large number of developers were required to take part in this investigation and to provide evidence as to their leasehold and sales practices. For the purpose of my talk today, I'll only mention the CMA's concerns regarding the doubling ground rents, but they were looking much more widely into unfair practices across the sector in general. As you may be aware, enforcement action was taken by the CMA to address their concerns regarding ground rents in particular, in respect of breaches of consumer protection law for leasehold homes. This enforcement action focused on the practices of 4 well-known nationwide developers, and those developers have since provided undertakings to the CMA to rectify what has been found to be bad practice. So what should you do with doubling ground rent now? If you're aware of properties within your portfolio that contain doubling ground rents, does this mean you need to leave the room immediately, inform everyone you work with that you're at imminent risk of CMA action? The good news is not necessarily. Doubling ground rents are by far one of the most publicised and well-known offenders in the current leasehold market. However, this doesn't mean that they are always unfair or that they will always affect leaseholders and the value of their properties in the way I mentioned a moment ago. The CMA has taken enforcement action in respect of ground rents which double every 10 to 15 years, and it's those terms that landlords have had to remove from their leases. These provisions should therefore be avoided at all costs in your leases. However, doubling ground rents are still acceptable. For example, the UK Finance Mortgage Lenders Handbook, which is a handbook setting out the requirements of English lenders for them to lend against residential properties. That specifically states that they have no objection to a lease which contains provisions for periodic increases of ground rent, provided that the amount of the increased ground rent is fixed and can be readily established, and importantly, that it is reasonable. If you're considering a doubling ground rent, then it would be prudent to ensure that the review period, i.e. the doubling, takes place no more than once every 20 years. And you should consider capping the ground rent so that it won't increase any further at around the 125-year mark. If you're still with me and listening to me talk, I presume that you don't have doubling ground rents, but you're likely still to have other ground rents in place. So what should you do about those? There are no concrete answers to this question for now, but I hope I'll give you some ideas of things that I've seen in the market that you can take away and think about. As I've mentioned, there's a lot of publicity about bad leasehold practices, bad developers, and this new legislation that will govern ground rents. But there's nothing currently in force that affects a landlord's ability to charge a ground rent. Even when the legislation does come into force, it will only apply to new long residential leases and not retrospectively to any existing leases. I think it's also worth pointing out that there's no current timeline for the implementation of this legislation either. Given the parliamentary time that's been needed for Brexit and now COVID, skeptics would suggest that it could be really some time before Parliament can dedicate the time it needs to see this bill through to legislation. One option, therefore, is to simply do nothing. Carry on charging ground rents as you have done previously within your portfolios. And as it stands, you'd be doing absolutely nothing wrong by doing this. And I know plenty of developers that have adopted this approach. However, that doesn't mean that it's necessarily entirely palatable either. And it does perhaps present a reputational issue that you may want to consider. Many home buyers will now be aware that ground rents can be an issue, and it's increasingly being raised as a pre-contract inquiry as to whether the requirement for payment of ground rent can be removed from the draft lease. That being said, my experience of the market with my developer client base, and even to some extent with my residential purchases, is that this is not currently causing any major issues. And whilst some purchasers will be put off and walk away from a transaction because of the ground rent, the majority will accept the need to pay a ground rent, provided it falls within appropriate boundaries, and certainly provided that it's at a level accepted by their lender. The opposite view to carrying on as normal would be a much more proactive approach of scrapping ground rents at sites entirely. This is quite a radical option, I think, although I am aware of developers who are doing it for their new or not yet build complete developments. This has the benefit of avoiding the reputational issue that I've mentioned previously, and may allow developers to market themselves as being more modern, upfront and transparent, which would help gain the trust of a buyer and ultimately could help boost sales. However, this isn't a decision that can be taken lightly, and it must be considered at an early stage of the development, as it's likely to have an onward effect throughout the life of the site. For example, it would make selling the development to a ground rent investor in the future impossible, because the income stream would no longer exist. And so thought would need to be given as to what you intend to do with the freehold to the development once you've finished building and sold all the sites. Another thought that comes to my mind when considering this issue is whether the scrapping of ground rents could lead to other problems. For example, could developers look to increase the original purchase prices for the new long residential leasehold property? Would they look to do that to lessen the blow of losing the ground rent over the coming years, or the loss of the freehold sale, which is based on that ground rent income in the future? I suppose we'll need to wait and see. Then, of course, there's something in the middle. To my mind, this would look something like a ground rent at 0.1% of the value of the property, which either doesn't increase, or if it does, the increase is RPI linked and is reviewed and increased not more than once every 5 to 10 years. I'd note here that the less frequently the rent is reviewed, the fairer it is likely to be considered to be. There's one further issue that I think is worth touching on before I hand over to the next speaker, and that is what you should do if you've got multi-phase developments or developments that use Help to Buy. Here I'm particularly thinking about large-scale developments that are, as I say, multi-phased or will complete over a number of years, and again, developments that are selling with Help to Buy. Let's say, for the sake of example, that you're building a scheme which is going to take several years to complete, and you intend to build that over 4 different phases. Phase 1 was build complete in 2020, and the leases for this phase charge a ground rent. This shouldn't cause any issues, other than if the ground rent is doubling or otherwise particularly onerous, in which case it may be prudent to take steps to rectify such provisions. Moving on in the build schedule, phase 2, that was built earlier this year in 2021, and that lease also charges a ground rent, the same as it did for phase 1, because you've used a similar lease template and business model across the scheme. For the same reasons, this shouldn't be a particular cause for concern. However, if you're selling the units in this phase with the benefit of Help to Buy, then as of earlier this year, Help to Buy has prevented ground rents from being charged on Help to Buy units. This phase of the development will therefore have some leases which charge a ground rent and some which do not. Carrying forward with the build, we move on to phase 3, and that's due to be built complete in stages throughout 2023. For the purpose of my talk, let's assume that the proposed ground rent legislation comes into force in June 2023, so midway through the year. You could therefore have a situation in which units which completed at the start of the year charge a ground rent, as the legislation doesn't apply retrospectively. You have some Help to Buy units, which you can't charge ground rents on, and now you also have some private sale units, which you can't charge ground rents on, as the legislation is now in force and preventing you from doing so. Phases 2 and 3 are therefore a little trickier to manage than phase 1. Carrying on with the build, you go into phase 4, and that's built sometime post the legislation. And that should again be relatively simple because you just wouldn't be able to charge the ground rent. As I hope this example demonstrates, the position pre-legislation, and once we reach a point where the legislation is in force, should be relatively simple and easy to manage. You'll either have a development which predates the legislation and can charge a ground rent under the lease, which you collect in the usual way, or it will post-date the legislation and it's not possible to charge a ground rent at all. However, some real thought will be required in respect of those properties that fall in the middle of these time periods, especially with the added complication of Help to Buy. The keeping of accurate records in order to ensure timely and correct collection of the ground rents is something that landlords and their managing agents are going to have to really get to grips with. I think I'm starting to run out of time at this point, and so I'll just quickly touch on reputation being another thing that's going to be important to be considered here. Whilst charging ground rents in the way I've set out in the example complies with all of the necessary laws and requirements, I suspect that homeowners in the future will be unhappy to learn that they're paying a ground rent where an identical flat in a different building is not, either because it's Help to Buy or post legislation. And whilst there are arguments which can be put forward to defend this position, it may be something that you want to give some thought to when you consider which approach you intend to take at the outset. I think I'll need to leave that there, but thank you for your time this morning, and I hope there was some helpful food for thought in there. I'll now pass you over to Daniel.
Thank you, Amy. If you bear with me a moment, I will just bring up my slides for today. I'm going to be chopping and changing between a few of them, but hopefully now you can see my slides. So I'm going to be talking to you today briefly about what are collectively known as the title deeds, the office copy of the Register of Title and Plan, a brief overview as to how to read it and a few tips as to what to look out for on these documents. So dealing first with the Register of Title, it's split into 3 registers: the Property Register, the Proprietorship Register, and the Charges Register. And I'll take you through each of those in a moment in some more detail. But first of all, let's just have a brief overview of a simplified version. Hopefully that's zoomed in. So this is a standardized office copy entry, as they're referred to, that you can go onto HM Land Registry's website and obtain a copy of them. I'll show you a few more detailed ones that have been redacted, but this is one that I haven't been working on, just one I pulled off of HM Land Registry as a simple example. So firstly, hopefully you can see my hand waving there. We've got the title number. So this is the registered title number, and this you also get at the top here the date of this particular copy, because of course they're updated from time to time, both the plan and the register. So here this is telling us it was, this shows you the entry at the 11th of January 2019, and that may well be important because you may want to see historical ownership, whether any charges have been removed, for example. It may be important to go back and find out a bit of history of the matter. So that's the sort of top part. Moving down, we have then, as I said, the first register, which is the Property Register, describes the land, and it will describe here whether it's freehold or leasehold, and whether it's absolute or possessory title. Normally where it's got freehold here, that's absolute title. We'll go into more detail about this in a moment. And it would normally be here within the Property Register that you will see whether the land has benefits of rights over other land, and that's important for a point that I'll deal with in a moment. Then we have the Proprietorship Register. This shows you who owns it, and as I'll show you in more detail in a moment, touching on some matters that Alex mentioned in his overage speech, it's here that you may see restrictions placed or notices placed to prevent or to flag up warnings as to when ownership is to be changed, or to prevent that. And also you can see the price that's paid. And then finally, you have the Charges Register, and this shows anything that affects the land, as it says there. And this could be a number of items, and I'll deal with that in more detail in a moment. But as I've said, this is just a simple register of title. As you can see, that's it for that one. So let's come out of there. So dealing first with the Property Register, so the first of those 3 that I mentioned, it will set out the nature of the title, as I've said, freehold or leasehold, its class. If it doesn't say otherwise, it will be absolute. But if for example, it's been acquired through adverse possession, it may only have possessory title. It may take a number of years before possessory title can build up to absolute title. So that's worth checking. If any benefits have accrued to that property. So it's what benefits attached to that particular land. So we're talking about, in most cases, rights of ways, easements that that land has over other property. And then also it normally refers to the plan, and we'll see in a moment, and it will be referred to the land outlined in red, but it may also have certain annotations to show bits that have been taken away, alterations that have been made over the years to the property, whether or not, particularly in the case of leasehold title, what strata is included, such as first floor, ground floor, etc. So that's the first part, the property register. The second part is the proprietorship register, in sort of essence, who owns it, what price has been paid for it. And then you have, as I said, touching on what Alex referred to about overage, restrictions can be placed at this point in time. You have a series of notices, either unilateral or agreed notices that can be placed, or you can have certain restrictions which would, for example, prevent the disposition of the property without either the consent in writing of a third party. This is normally the case where you have a charge. It can also be the case, such as in one of Alex's examples, where a previous vendor is trying to keep alive the overage agreement. And one way of doing that is to say, well, you can't change the ownership unless you get my consent. I'm not going to give consent unless I have the new owner enter into the ownership agreement, overage agreement with me. There's a lesser form, so it's not consent that's needed, but that it's notice needs to be given. And that may start a sort of scramble for action, because it doesn't prevent the change in ownership. It just requires that some evidence that notice has been given to a certain party that it's intended to change that ownership. And it's also used to reflect any trusts. So it may be that on inquiry, or that you need to dig around a little bit in order to see, well, what's that there for? Is there a trust? Are there any issues with that trust in terms of obtaining ownership? The final register, the charges register, the third part, deals with a number of different types of interests or burdens over the land itself. So we've got rights over land, easements, mortgages, charges, and leases as well, either in the case of freehold title or in the case of head leaseholds. So let's just then switch from here and have a look at, bear with me one moment, a more complicated title. So hopefully you should all now be seeing this property register, which runs to 17 pages. I've actually truncated it a bit. I think the final version was 29 pages, but it's a useful example to show a much more complicated title. And in fact, this is just as we can see here. So we've got, as we've seen before, the property register. So that's that part there. And underneath there, we can see that in this case, this isn't freehold, this is a leasehold title, shown edged red on the plan. And that's the plan. We'll have a look at a plan in a moment. We then have reference in the property register to various agreements. We also have, a bit further down, short particulars of the lease itself. And this is something you'll find. So it's the original, it's the lease that this title has been created out of. We get the date, we get the term, we get the rent. This doesn't look like it would offend anything that Aimee's been talking about. And then we have the parties to the lease. And then we have a note here of a deed of variation and a deed of rectification. This is a head lease of a large estate, large residential, well, mixed, but predominantly residential estate. And also in the property register, we see right at the end here, one of those restrictions that, or it's not the restrictions, but a benefit, sorry, that the land has. And it refers here to the land has the benefit of any legal easements reserved by transfer of the land edged and numbered on the title plan, and that's referring to the transfer dated the 21st November 2018. So if you're looking at that, you'd want to call for that particular document from the land registry or from the vendor, because you'd want to see what is being referred to in there, and that's going to usually relate to some benefit, and here it's expressly said to be some easement. So you'd want to know what's the other property you've got the rights over in relation to. So that is the first part, the property register. So that identifies the property and any benefits that go with it. And also in the cases of leases, it will set out brief details of the lease. We then move on to the next part, which is the proprietorship register. So this shows you who owns it. So first thing you have here is proprietor. You also get to see the price paid. And then going back to that point on restrictions, we have one here. And in this case, it's no disposition of the registered estate by the proprietor of the registered estate or by the proprietor of any registered charge, not being a charge registered before the entry of this restriction, is to be registered without a written consent signed by the proprietor for the time being of the charge dated 24th of March. That charge will be reflected later on under the charges register, but you can see there that that is a way of securing something. In this case, it's a charge. It could be an overage agreement. It could be some trust conditions. It prevents the disposition. So anyone buying this was going to want to be satisfied that that restriction is going to be lifted and they're going to be able to get registered title. We then move on to the charges register, so the third part of the register, and this contains a number of matters that affect the land. One point to bear in mind, it doesn't necessarily have to contain any rights of way that the land is subject to. It's the benefit of those rights that will be recorded on the title that has the benefit of them. So it's necessary to do a bit of investigation to have a look around. Is there anything obvious that you could see that there may be some rights of way by neighbouring lands? Ask the vendor as well in relation to that, and that will usually come through in the seller's property information forms or on requisitions. So the charges registers here, though, is setting out a number of agreements. We can start to pick up a few of them here. There's one 18th of September 1846. There's another one 6th of March 1987. It gives you the parties. The land registry ought to keep copies of these or the relevant parts on file, and you can request copies of those, or they'll set out an extract here. They do, though, quite like to shred or get rid of documents, so they may set them out extensively. So we can see here on item 3, we have the rights set out here, and we have them extensively set out. We've got the whole of the Schedule 2, Part A, Part B. This has been lifted from the relevant agreement, transfer document, conveyance, whatever, which is setting out the rights. And of course, this may also include restrictive covenants, of which we've also heard from Alex on, and it's a way of, particularly with restrictive covenants, making them run with the land as they would need to be registered like this in order to continue to be binding. So you can see this has got quite a lot of entries on the charges registered. And down here at the bottom, I've just picked up that this is just a highlight here. This is the lending charge to which the restriction we've seen applies to, and so there's that entry there for the registered charge. It looks like there's another registered charge for some dementia, and then we have the schedule of notices of leases. And as you can see, because this is a head lease of an extensive residential development, I've redacted them, but you can certainly see there's quite a number of leases there. So that's an overview of the charges register. Let me just share my screen now to take you back into the slideshow. So that's the charges register. And things to look out for then. Well, look out for easements. As I've said, they may not always appear on the charges register. That's one thing to be careful about. But certainly the benefit of easements ought to be there recorded in the property register as being part and parcel of the land or going along with the land. Various charges, of course, we want to make sure that they're going to be discharged on purchase. Any trusts, usually highlighted by the restrictions on dispositions, and then again, restrictions on dispositions, which could be for a manner of reasons for example, overage agreements. And then finally, any sort of planning covenants that are registered against title, such as those imposed under section 106. So moving on then from the register of title to the title plan itself. So this links in with the part of the property register which identifies the land. It shows you the location of the property. It normally does by outlining the property by way of a red line. There are other lines, other coloured lines, as we'll see in a moment, that can be set out there, which usually show the type elements that have been taken off that title. And they're all based on Ordnance Survey maps. That's a statutory requirement that they are based upon Ordnance Survey maps, which are regularly updated. So, and there's a couple of issues that I will deal with on scale and accuracy. So let's first of all have a look at some of the other issues though, but before I take you to the plan, things to look out for. Firstly, section 60 of the Land Registration Act, not 200, it's been 2002, is the what's known as the General Boundaries Rule. And this rather unhelpfully says that unless the boundary is shown as determined under this section, section 60, the boundary shown on the plan is a general boundary. And what does that mean? It means that it doesn't determine the exact location of the boundary. So the registry, the title doesn't show the exact location. And this can get more tricky in a number of scenarios, particularly when you have, when you bear in mind differing scales that Ordnance Survey use, which is then used on the title. So where we have urban regions, normally it's 1 to 1,250, which shows a certain extent of detail and accuracy. But when you get to more rural areas, it's 1 to 2,500. And then when you get to more remote areas, it's 1 to 10,000. And why is that important? Well, obviously for accuracy, but then you've also got to take into account certain issues about Ordnance Survey map features. If there is something that is more than 0.3 meters high, then you will see a firm line. If it's below that, you will see a dotted line, and we'll see how that is reflected in a minute on the title. But where there are parallel lines are less than 1 meter apart on an urban plan, or 1 to 1,250, or less than 2 meters apart on a rural plan of 1 to 2,500, only the preferential feature is shown. So you could have two lines, two fences, a gate and a fence, or railings and a fence, and you would, or the side of a building with a fence, but you would only see one line. And then that's picked up as to whatever the land registry think the preferential feature would be. I suspect on the side of a building, it'll be the side of the building rather than the railings, but there's a little element of subjectivity in that. But you can see there then that there is a risk of the map itself or the plan itself not showing you with enough detail, not only because of the scale, but because there's a tendency to blend then features which may appear to be boundary features. So let's just bring up now a plan. It's all to have a look at. So hopefully you can all see that now, and I think I can zoom in. Yeah, right. Before zooming in, worth just taking a moment to take stock of what we've got. So this is what comes with the registered title. This is the copy of the plan. Its title number is given at the top here, and then there's also an Ordnance Survey map reference. So that's for the greater Ordnance Survey map. Gives you the scale of 1 to 1,250, which we've seen because this is a rural area. And you also get the administrative area, and you helpfully get to orientate yourself with a compass point. So let's zoom in here on this particular title. Now, what we've got here is this is in fact titled to, was titled to a larger plot, the whole red plot that we can see here. But the actual register for this says that these green parcels were taken out at various stages. So in fact, all that this title refers to is this small nub here, which was an entranceway to a garage. And you can already start to see that, albeit when you're on the ground, it might be much easier to see where the boundaries are. These are probably brick walls here of properties, or a wall here. It's not quite clear. What are these extra parts here? Is this a forecourt? You've got lines, you've got one line here, but that could well have another fence in front of it that is less than a metre apart. This dotted line here is the curb of the streets. But it gives you an idea here that when you have these lines on the plan, not only do you need to possibly make more investigation as to that, particularly on a sort of tightly constructed plot here and where it's been changing hands from over the years, but you need to make sure that two boundary features, well, there are potentially two competing boundary features here, and you've got the inner red line and the outer green line. I mean, I think you'd probably take the black line as some indication as to where the boundary is. But again, you've got to step back and think, well, there's the general boundaries rule, so I can't really take that entirely for granted. I've got to look at either some conveyancing documents or the history of title, if there's any dispute as to how far the boundary extends to. So I think I'm going to stop sharing at that point. Hopefully that's given you a rather quick, in the time allowed, overview as to how to read the office or the title deeds, and give you some sort of steer as to what to look out for. Thank you very much. I'll pass over to Jonathan now.
Thanks, Daniel. Right, good morning, everyone. So I'm going to be talking about claims for time and money. So surprisingly, on construction sites, sometimes they run late and sometimes they run over budget. So a claim materializes if it's really over budget and very late. So I'm looking at it from this position of the employer and the contractor. So depending on the contract, when the project is in delay, the employer's side, well, he can claim liquidated damages, and from the contractor's side, he can apply for an extension time and additional costs. I'm going to concentrate on the extension time, additional costs, and seeing how both parties can meet that. Next slide, please. So the cost claim. What are the costs that a contractor will incur on the project when the program is delayed and he misses the completion date? So I've set out there the normal heads of claim that a contractor will submit. The first two are additional site overheads and additional head office overheads. So that's being on site longer than he planned. There'll also be cost of financing. The contractor will have borrowed money to pay subcontractors, pay for materials, and he will have to take out extra finance. And finally, if the contractor is on site longer than he anticipated, he'll have other claims such as loss of profit or loss opportunities. So the contractor is going to say he could have tendered for all these jobs, but he hasn't because he's on site, our site, longer than he anticipated, and therefore he's lost the opportunity of taking on another job, and he's lost the profit from that job, and he'll seek that money off the employer. Next slide, please. So how does the contractor prove an entitlement? So first of all, if we're talking about delay, it's got to show that there's been a critical delay event which the employer is responsible for and which gives the contractor an entitlement to an extension of time. Now, the important point here is a critical delay. Not every delay event is critical. Sometimes it's a delay event, but the contractor could be doing other work on site and still hit the completion date. So here it's a critical delay event which actually hits the critical path of the program and prevents the contractor from achieving the completion date. So for example, let's say there's really bad weather and he can't make the building watertight and stop building inside. That would be a critical delay event normally. And then the second thing the contractor's got to prove is that he's actually suffered additional costs because of this delay event. And then he's got to marry the two together. So he's got to show a direct link that the delay event he says is critical here, or that delay event has cost him this amount of money. So showing how the two things are interlinked. Next slide, please. So if you're the employer facing an extension time claim, the thing you're going to be looking at is there any concurrent delay? So what is concurrent delay? Well, true concurrent delay is where there's two delay events which happen exactly at the same time, one which the employer is liable for and one which the contractor is liable for, and they fell at the same time. Now, it's very rare in practice that two concurrent delay events happen exactly at the same time. So what concurrent delay actually does mean is where there are two or more delay events which arise at different times, but their effects are felt at the same time. So let's give an example. Let's say an employer issues a variation changing the design of the bathrooms. So that will be a delay event which the employer is liable for, and the contractor says, gives him an extension of time. But the employer turns around and says, well, actually the building isn't watertight because you've not been progressing the works. So regardless of whether I issue that instruction or not, you couldn't have done the bathroom works. So there's two delay events which are running concurrently. And the law in that position at the moment is the contractor still gets an extension of time. He gets relief from liquidated damages, but he gets no entitlement to loss and expense. Next slide. So how do you assess delay? Well, there's some considerations which I'm going to look at in more detail. You've got to look at the specific requirements of the contract. How do you notify a delay event under a contract? Then carry out some delay analysis. The two main ways of doing this are prospective. So that's saying there's a delay event and looking ahead, how will it impact on the program, or retrospective. So when the program's finished, the construction project's finished, you look behind and say, how has this delay event caused the delay? Then you've got to look at the nature of the delay events being considered. Some delay events the employer will be liable for, and some delay events will be for the contractor. Look at the available records, program information. What was the critical path? The time available. Is there flow to the program so the contractor could have made good on the delay? And look at the value of the dispute. If we're not talking about huge sums of money, there's not really much merit in spending a lot of money on doing a delay analysis and bringing a claim to litigation. Next slide, please. So here are some of the main methods of carrying out delay analysis. There are many ways, but these are the four most common ways of showing critical path and critical delay analysis. So let's go to the next slide, please. As planned, impacted. So this is a prospective method where the impact of the delay events on planned activities and sequences is identified and assessed, and then inserted into the plan logic. The adjusted program retains the original logic, so the result shows what the plan might have been at the outset had the programmer known about the delay events which have ultimately occurred. Now I've set out here and on the next slides pros and cons of all these programs. I won't read them out. If you want, I'm very happy to give you copies of these slides and you can have them for your own records. Next slide, please. Collapse as-built. So this is a retrospective analysis where you have the as-built program, which is assessed, and impact periods are identified and removed to show how the project would have been performed absent those delay events. Then you have a comparison between the as-built and the collapse model, which then bingo gives you your period of delay. Next slide. Windows analysis. This is by far, I would say, the most common form of delay analysis. The project is dissected into discrete periods of times or windows, let's say, for example, monthly, month by month. So each month has its own program update. Each period of time is analysed to assess the shift in the critical path and the shift in the completion date during that month and the reasons why it's happened. And then the delay is attributed to the relevant party, be it the employer or the contractor. Next slide. And finally, time impact analysis. This requires a program which has been updated up to the point just before the delay event has happened. The critical path and anticipated completion date are then identified. The program is then altered to model the effect of the delay. So you're adding the activity or change the sequences or durations. The program is then again rescheduled to show the new critical path and completion date and the critical impact caused by that delay event. Next slide. So those are the ways, some of the ways you can work out why the program has been delayed. So what are the common problems when the contractor presents its claim to the employer? Well, a contractor can lose its right to bring a claim either in part or completely because it doesn't follow the procedure and the mechanism of the contract to notify delay events. And I'll look at this in more detail in a minute. And also, contractors are sometimes unable to get all their money back because they don't prepare their claims with the care and details required. So they don't carry out a detailed analysis, or they don't have the contemporaneous records to show what happened on site to explain why the project was delayed. Next slide. So now we're going to look at the problems with looking at the contract and how you claim an extension time. It's very important that you read your contract and see what it says about notices. There'll be clauses in it about notifying the employer or contract administrator about delay event, how those notices should be drafted, and where they should be sent to. Now, some contracts have a clause which is called a condition precedent clause, which, unless the contractor complies with, he will lose his right to claim an extension time and loss and expense. And I think the best way to explain that is to show you an example of a condition precedent clause. Next slide. So this is a FIDIC contract, which some of you may be familiar with, and it's clause 20, which sets out what a contractor does if he wants to notify the contract administrator or the employer of an extension time. So if you look at the bits that are underlined, the contractor's got to give the notice as soon as possible and not later than 28 days after he becomes aware or should have become aware of the delay event. If he misses that 28-day deadline, then he loses entitlement to an extension time and loss and expense. So that's a very severe clause. A lot of people like to amend their JCT contracts to put in a condition precedent clause, the extension time mechanism. Obviously, a lot of contractors fight back at tender stage because they don't like them. Next slide, please. So, in conclusion, look at your contract and don't be scared to issue a notice. If you're an employer, you're going to issue a notice of non-completion, and if you're a contractor, you're going to issue a notice of delay events. It's important for both parties to maintain accurate records so that when the project's finished, they can look back and show why the project was delayed. So the obvious examples there are minutes of meetings, progress reports, emails, and notices, updated programs. I appreciate that doesn't often happen. Photographs which are dated, the site diaries, the labour records, and of course the invoices to show loss. When you come to serve your notice, must comply with the requirements in the contract, both from the content of the notice and also how the notice is served. You don't fall foul because you've served the notice to the wrong address or by the wrong delivery method. And finally, if you do serve a notice and the other party doesn't respond, don't be nervous to contact the other party and get them to respond if you have to. Thank you. That's the end of my talk.
Thanks, Jonathan. We've slightly overrun. Maybe there's time for a couple of questions. Let me just see if there's any questions that are coming in. Here's one for Daniel. So Daniel, the question is, how are disputes resolved over title?
Well, there's two main methods, well, three, I suppose. One is the parties can negotiate and hopefully reach agreement. But in the absence of that, normally one party will write in to HM Land Registry, either to try and object to something, or if someone wants to put a notice on or to change something, and to alter title that way. If Land Registry is satisfied that that should go ahead, they may make the alteration. If they're not satisfied, what they might do is, if an objection is put in that isn't groundless, they'll refer the matter on to the first tier tribunal, land registration, who can deal with that dispute and decide whether or not the title should be altered effectively in the way that's being sought. Alternatively, the parties can litigate through the courts in order to get declarations as necessary, or even the courts have got powers to order the land registrar to make alterations on title.
All right, great. Thank you very much, Daniel. Let's see. Yeah, there's another question here. A question saying, what are the problems with the developer taking a charge over to protect overage? Right, so problems with so a charge is a very effective method of securing overage, yeah. Because what happens is if it's not paid, you can then you can the seller can enforce its charge, sell the land, and recover its overage out of the sale proceeds. But you've got to be very careful that there's no what's called a clog on the equity of redemption. So it's important, in other words, that the charge the mortgage must be capable of being redeemed. You can't agree an irredeemable charge. So you need to have a fixed period to trigger the overage. And there are problems, obviously, with because of from a buyer's point of view, it could prejudice its ability to raise finance, and often you're going to have some sort of deed of postponement with any existing other alternative providers of finance, which is going to cost time and money in terms of agreeing the relevant financing documents. I hope that sort of answers that question. Are there any other questions? Let's see. Here's one for, yeah, let me just see if there's anything else. Okay. There's one on this Competitions and Markets Authority thing. Aside from the actions that have been published, has anything else come out of the investigations from the CMA? I think that's probably Aimee. Yeah.
Yeah, I think the other main thing to have come out of it is that they've set up sort of a pledge system, and around 70 or so developers have signed up to that, in which they basically pledge that they won't, if their leases contain doubling ground rent provisions that double more frequently than every 20 years, they'll get those removed from their leases and replaced with RPI based ones, or they'll assist leaseholders in getting that change if the freehold to the development's been sold, and they agree not to insert them anymore. I think that's probably the main thing.
Okay, I'm sorry, it's 11:10. We've kind of run out of time, I think. I hope everybody's enjoyed this webinar, and any follow-up questions you have, please send them through to us. I think that you should be able to contact us by email or by phone. Thank you very much for listening. Thank you. Right, thank you.